Yeah. Welcome back, sir. Welcome back to the world of law. Welcome back to the world of HD. So we'll revise the Companies Act. Rapid revision. Yes or no, sir? See, its weightage will be 21 marks. How many marks, sir? Companies Act weightage will be 21 marks. You can expect the question in the question 1, question 2, question 3. In 3 questions, second part will be Companies Act. In every question, 3 parts will be there. 1A, 1B, 1C, 2A, 2B, 2C. And 7 plus 7 plus 6, 20 marks. Here, you can expect this question in the 1B, 2B, and 3B. Yes or no, sir? 21 marks totally. 7 minutes and 7 marks, you may get the 4 plus 3. You may get 2 plus 2 plus 3. So something like that you can expect. The beauty of the Companies Act, the Companies Act will be there in the CA foundation. It will be there in CA enter. It will be there in CA final. It will be there with you till you die as standard accountant. So partnership is like a crush, passing clouds. They will come, they will go. But Companies Act, GST, income tax, it's like a wife, it's like a husband, it's like a sky. Once comes, it will not leave. Done. Very, 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 very important act in your life. Let us understand the fundamentals of the Companies Act. See, first of all, what is the history of the Companies Act? Whether company is an English word or not. So, what is the meaning of the general meaning of the company? Company means a business organization. Company means a what company is doing which makes money. How? By producing and selling the goods and general meaning. In layman language, company means a business organization. Infosys is a business organization. Infosys is making the money by producing and selling the service. Tata Motors is a business organization. Tata Motors making the money by producing and selling the goods. Yes, sir, no, sir. Basically, the word company is not a English word. It is a combination of two Latin words. Come plus pane. Come means together. Pane means bread and butter. Company means working together. Working together. Together. Bread and butter for oneself and their family members. So, what is the history of the company sector? During the Industrial Revolution in European countries, people faced a lot of difficulty to get the food and butter. So, based on the instructions of the king, people used to come together. They used to discuss. When they discuss, they will get the idea. When they implement the idea, they may be getting the good or the service. If they sell that good or service, they will get the money. So they can get the food and butter. So in general, exact meaning of the company means working together to get the food and butter for oneself and their family members. Subsequently, in 14th and 15th century, it is included in the English dictionary, so it becomes the English word. Basically, it is a combination of two Latin words. Yes or no, sir? So what will be there in the company set? So we don't know company set. इसमें क्या रहता sir? Summary. It contains the rules, regulations, formalities for formation of the company, management of the company, and dissolution of the company. The company set contains the provisions regarding how to form the company, how to manage the company, how to dissolve the company. Yes sir, no sir. So all these provisions are, we have 470 provisions. How many provisions are? 470 provisions divided into 29 chapters and 7 schedules. The company set is containing 470 sections divided into 29 chapters along with 7 schedules. Yes or no, sir? So these are the chapter names, sir. Chapter 1. Chapter 1, section 1 and 2. Chapter 2, section 3 to 22. Till here we will discuss in the CA foundation. Done. Clear, beta? Section 1 to 22 we will discuss in the CA foundation. From 23 we will discuss in the CA enter till section 148. Till here we will discuss in the CA enter. So remaining part we will be discussing in CA final. Yes or no, sir? So this will be there in foundation and enter and final. Who is passed in the Companies Act in the Parliament of India? This act was passed in the Parliament of India by the Central Minister Piyush Goyal. He is a chartered accountant. And this is the 18th Act in 2013. Before this Act, 17 Acts were passed in the Parliament of India. So, if you see the preamble of this Act, it is an Act to consolidate and amend the law relating to companies. It contains rules, provisions for the how to form the company and how to manage the company. Date of enforceability. This Act is getting the consent of President of India on 29th August. It is published in the official gazette on 30th August, but it is applicable from 12th September 2013. It contains 29 chapters and 7 schedules and 470 sections. In foundation level, we will discuss only first 22 sections only. And then to whom this act will be applicable? This act is applicable to whole of India, including Jammu and Kashmir. This this act is applicable to whole of India, including Jammu and Kashmir. This act is applicable to company formed under this act, company formed under previous companies act, and insurance company formed under insurance act, banking company formed under banking act, electricity company formed under electricity act, or any other company formed under any other special act. Basically, insurance company governed by insurance act, banking company is governed by banking act only. Why we are applying the companies act to insurance company or banking company? Whenever the provisions of the special act are silent, we will apply companies act. See, basically, insurance companies are governed by insurance act only. If insurance act is silent, we will apply companies act. Banking companies are governed by banking act. If banking act is silent, we will apply the companies act. So this act is applicable to company formed under this act and previous companies act. And also insurance company, banking company, electricity company, or any other company formed under any other special act. We will apply companies act if and only if the special act is silent. Done. Then we start with the definitions better. Definition of the company is given by section 220. What is the meaning of company? Company means a company. Company means which is incorporated under this act or any of the previous companies act. SG Limited is formed in the year 2023 under Companies Act 2013. So SG Limited is a company. Otherwise, Infosys formed in the year 1995 under Companies Act 1956. So Infosys also company under this Companies Act. Company means a company formed under this act or any of the previous company law. Then we start with the beautiful features of the company. Which features are beautiful features of the company? Yeah. First feature is the company's voluntary and incorporated association of persons. To incorporate a private limited company, there must be voluntary association of two subscribers, not the shareholders. Two subscribers. Public company, 7 subscribers. One person company, 1 subscriber and 1 nominee. The person can be natural person or an artificial person. Company can be formed for doing the business and to make the profit. It can also be a non-profit organization. But company can be formed only for the lawful purpose, but not for the unlawful purpose. And then we discussed about the artificial person. Company is an artificial person, but not a fictitious person. Fictitious means not there. Artificial means it is there, it is not visible. Company is like a Bhagavan. So Allah is there, Jesus is there, Ram is there. Can you show me Bhagavan? No, still he is there. It's like a air. Can you show me air? Still it is there. So company is like a air. Company is like a Bhagavan. And is there, but not visible. Artificially something is not there. Company is an artificial person, but not a fictitious person. It is a person in the eyes of it is visible only to law, and which can do everything what a natural person can do. How company can do everything through shareholders, officers, employees, directors. However, this company will not suffer from the old age, illness, and death. It does not have the physical existence. It is there, but no physical body. It is invisible and intangible. You can't see the company, you can't touch it, but it is there. It is visible only in the eyes of law. Next, we discuss the concept of the separate legal entity. Separate means different. Legal means law. Entity means organization. Company is a separate person in the eyes of law. So we discussed. Dhirubhai Ambani, following the procedure prescribed under the Companies Act, he found a baby called Reliance. By birth, Reliance said, "Hey, Papa, Dhirubhai, you are different. I am different. For your activity, you are liable. For my activity, I am liable." Dhirubhai is asking, "Who said you? You are different. I am different." Mummy. Who is Mummy? Companies Act. Between you and me, wheel is there. What is that? Wheel. Cloth. Corporate cloth is there. Invisible cloth is there. This cloth is separating you and me. For the activity of directors, promoters, shareholders, they will be liable. For the activity of company, company will be liable. इसको बोलते हैं separate legal entity. ये देखो बेटा, company is there, shareholders are there. one side company, one side shareholders. Between them, what is the imaginary cloth? Is there which cloth? This cloth separating the company from the shareholders. Or so company is a separate from the members forming the company. So company अलग होता है, members अलग होता है. Company is a separate person having its own rights and obligation. Company has its own duties and rights. Assets of the company will be held in the name of the company. Liabilities of the company incurred in its own name. So for the liabilities of the company, shareholders are not liable. So Satvika is there, Prasanna is there, SG is there, like that info is also there. Prasanna is there, Sahiti is there, and SG is there, like that info is there. Info is also person, but invisible and intangible. So members are not liable for the activities of the company. Company enter the contracts in its own name. We can sue the company. Company can be sued also. Company is a separate person in the eyes of law. This was explained by a famous case, the Salman versus Salman Company Limited. This was decided in the year 1897 by the Lord Macnaghten. So what was happened in this case? So in London, so there was a street called Whitechapel Road. Which road? In that gully, there is a big tree. Which tree? Big tree. Under this tree, there is a person called Salman. There is a person called. So what he is having? But he is having a shop. Which shop? Shoe. He makes the shoe. He sells the shoe. So trader. Yes sir, no sir. One fine. When Tweety entered into his life, Tweety and Salman got married. Cut chase there. Down the line, they're having the four sons. How many sons? Sir? And one daughter. So he's leading the life, making the shoe, selling the shoe. One fine day, Salman is thinking, why can't I form the company? So for farmers to the public company, we require 7 subscribers. So Salman do, his wife, 4 sons, 6, one daughter, 7. With all his family members, he formed a company called the Salman Company Limited. Once company takes its birth, company will be different, shareholders will be different. Between them, corporate will be there, which will this will is separating the company from the promoters of the company. But the company said, hey Papa, Salman, you are different, I am different. For your activity, you are liable. For my activity, I am liable. Then Salman was asking, who said you are different, I am different? Mummy. Who is the mummy? Company said. Yes sir, no sir. After formation of the company, Salman selling his business to company for 38,782 pounds. How many pounds, sir? So Salman is doing the business to company. Company has to pay 38,782 pounds. Out of that, cash is given 8782, shares 20,000, and debentures 10,000. Which debentures? Secured debentures secured on the assets of the company. Subsequently, company went into liquidation. On the date of liquidation, worth of the assets was 6,000 pounds. Liabilities was 17. Out of the 17, how much we have to pay to Salman? 10,000, which is secured on the assets. How much is the outside creditors? So 7,000. What's the argument of the outside unsecured creditors? They argue that company and Salman both are one and the same. But judge held that no. Salman is different, company is different. Since Salman is the secured creditor, he must be repaid priority over the outside unsecured creditors. And because of this case, now there is a concept of the separate legal entity. Clear? Next concept is the limited liability. Which liability, madam? See, we will see the company names like SG Limited, Infosys Company Limited, SG Private Limited Company. The word limited will never define the liability of the company. It defines the nature of liability of the members of the company. The word limited is there now in the company name SG Limited. Is it define the liability of the company? No, it will define the nature of liability of the members of the company. So based on liability, companies are 3 types: limited by shares, limited by guarantee, and shares and guarantee. First of all, if it is a company limited by shares, the face value of the share is 10 rupees, issue value of the share is 10 rupees, paid up value of the share is 6 rupees. But the unpaid value 4 rupees. If it is a company limited by shares, the liability of each shareholder will be maximum to the extent of unpaid amount on the face value, including premium if any. Yes sir, no sir. Then if it is a company limited by guarantee. For example, there is a bank, State Bank of India. There is a company, SG Limited. There are 1,000 members are there in the company, not the shareholders, members, pure guarantee company. each member said I will give 100 rupees. When if SBI is giving the money to company, company has to repay. If company is unable to repay, member will pay. Each member how much he will pay? 100 rupees. The liability of each member will be 100. So who is this member? Surety. Member is the surety. Yes sir, no sir. So the liability to member will come if company is unable to pay. When better? If company is unable to pay. Company is unable to pay means liquidation. So the liability to member will come only during the winding up of the company, and the liability of each member will be unpaid amount on the unpaid amount on the sorry guarantee amount specified in the memorandum of association. If it is a company limited by guarantee, so the liability will arise to shareholder only during the winding up of the company. It's said to be contributory. He has to contribute to assets during the winding up of the company. The assets of the company in the event of being wound up. So here contributories are of two types. List A contributory, list B contributory. List A contributory means existing members. If they are unable to pay, previous member has to pay. Who's the previous member 1 year before the date of insolvency? Is said to be list B contributory. So when member has to pay, if company is unable to pay, then why these companies are created? These companies are created as a charitable purpose to promote the arts, science, commerce, religion, charity, sports. How they will get the initial capital? They will can able to satisfy the initial capital requirements in the form of donations, subscriptions, entrance fees. Then next, company limited by shares and guarantee. Here, the liability of the member will be twofold. That is unpaid amount on the face value of the share and also the guarantee amount. This face value can be called by company at any time. At a guarantee amount can be called only during the winding up of the company. Then we discuss the perpetual existence. Perpetual existence, superstar, very very important. But the life of the company does not depend upon the life of the members. Members may come, members may go, members may die, but company will remain same. So who's creating the company? Companies Act. Death, insanity, insolvency of the member will not affect the life of the company. The life of the company does not depend upon the life of the members. Members may come, members may go, members may die, but company will remain same. The company is created by process of the law. To dissolve the company, also we have to follow the procedure prescribed under the Companies Act. Even by death of the all the shareholders, company will not be affected. Then perpetual existence. Perpetual existence. Next, separate property. Property of the company is separate from the property of the shareholders. I am a shareholder of the Reliance. Reliance is having a building in Hyderabad, Madhapur. That is registered in whose name? Reliance name, but not in the SG name. I have a building in the Kukatpalli. It is registered in SG name, but not in the Reliance name. Yes or no, sir? Being a separate person in the eyes of the company is capable of acquiring his own property. Shareholders cannot be described as the part owners of the property of the company. Yes or no, sir? Property of the company will be held in the company name. Property of the shareholders will be held in the shareholders name. Then we have seen a famous case like Makura versus Northern Assurance Company Limited. So what was happened in this case? Makura versus Northern Assurance Company Limited. So Makura formed a company, Timber Depot, with his wife. Majority shares in whose name? Makura name. Makura has taken the insurance policy on the closing stock of the company, and stock was destroyed. But who can take the insurance policy? Company. But who is taking? Makura. Can I take the insurance policy on the property of my neighbor? No. Court held that the company can take the insurance policy, but not the Makura, because property of the company separate, property of the shareholders will be separate. Then will Makura win the case? No. Clear. Next concept is the transferability of the shares. Next concept is the transferability of the shares. As per section 44 of the Companies Act, shares are transferable property. Which property? Movable property. We can buy and sell the shares. In case of public company, shares are freely transferable without any restrictions. In case of private limited company, transferability is restricted but not prohibited. In case of company to transfer the shares, I need not take the consent of all the shareholders. In case of partnership firm, if I want to sell my share, I should take the consent of all other partners. But in case of company, all other shareholders' consent is not required. Then common sale. A sale important, sir. This question also important. Common sale. Common sale is the signature of the company. So every company will have its own signature in the form of common sale. Once common sale is affixed, it is deemed to be signed by company itself. Common sale is affixed on the share certificates, debentures, and negotiable instruments. Generally, CS and directors are authorized to use the common sale. If common sale is not mandatory from 2014 because we can have the electronic signature. Which signature? Electronic signature. If company does not have the common, if the company does not have the common sale on behalf of the company, it must be signed by two directors or one director and CS. This one is very very important. If company does not have the common sale, who should sign this? Two directors or one director and one CS should sign the agreement on behalf of the company. Clear? Bolo. Next one is the separation of the ownership and management. Who are the owners of the company? Shareholders. Who will manage the company? BOD. Who is appointing the BOD? Shareholders. Who is removing the BOD? Shareholders. Who has the ultimate control? Shareholders. However, once management of the company is given to shareholders, given to BOD, shareholders should not interfere into the day-to-day activities of the company. Once again, so company is controlled by the board of directors, and once management is given to BOD, shareholders cannot interfere into the day-to-day activities of the company. Directors are elected as well as removed by the shareholders itself. So ultimate control is with the shareholders itself. Then is Narayana Murthy is the BOD of the Infosys. Mukesh Ambani, BOD of the Reliance. Then next one is the capacity to sue and being sued. Company is a separate person in the eyes of law. So I can file a case on the Satish, Satish can file a case on me. In the same way, I can file a case on the company. Company does something wrong, and company can file a case on me if I am doing something wrong with company. Yes or no, sir? So these are the 10 beautiful features of the company. The next concept is the corporate will. Which will? This concept is very important from exam point of view. Star, superstar, star, mega star, 10 stars. Corporate means company. Corporate means company. Wheel means cloth. Wheel means curtain. Yes or no, sir? So there is an imaginary cloth. Which cloth? Imaginary cloth between the company and promoters. Company and, for example, this is the cloth. This is the cloth. For this cloth, एक तरफ shareholders, एक तरफ directors, promoters. Sorry, one side is company, one side is the promoters, shareholders, and directors. This cloth is separating the company from the directors, company from the shareholders, company from the employees. Yes sir, no sir. Corporate will means imaginary cloth between company and its shareholders, directors, employees. What this cloth is doing better? For an activity of company, company is liable. For the activity of shareholders, shareholders are personally liable. Yes sir, no sir. However, behind this wheel, if any director, if any shareholder, if any promoter taking unfair advantage, then wheel will be lifted. They will see the person behind the wheel. Wheel is there, no? Behind the wheel, any promoter, any director, any shareholder doing the unfair advantage, doing any unfair activity, then court will lift the wheel. Court will, they will see the person behind the wheel. They will punish the person behind the wheel. Yes sir, no sir. So we discussed the case laws also. First one, for the production of the revenue, Sir Dinsha Manikji patent. Sir Dinsha Manikji, this is very important case, beta. This came nearly 10 times in the exam. Star, superstar. Star. So, corporate will be lifted under different circumstances. And the first one is the for the production of the revenue. Production of the this case was asked so many times in the exam beta as it is star, superstar, star, mega star. So what was happened in this case? Sir Dinsha Manikji pitted. So there is a famous person called is a rich person, retired army officer in the British Army. Sir Dinsha. Sir, since he's a wealthy man now, he's having so many employees. He's a smart worker. Which worker, beta? So he used to invest in the share market to get the dividend and interest. After retirement, Dinsha was getting a lot of money. He's investing in the Infosys shares, Reliance debentures, SG Limited shares, Wipro debentures. From each company, he used to get the dividend and interest, dividend and interest, dividend and interest. This was happened in the year 1927. For example, Dinsha income is 40,000 rupees per annum. How much? As per income tax laws at that time, 10,000 is exempt. How much is taxable? Beta? 30. So he has to pay income tax. But Dinsha don't want to pay tax. But licensing, law is everyone. So what to do? Dinsha, with help of his 4 employees, he has 4 employees: Sweetie, Cutie, Naughty, and Puppy. So with these 4 employees, he formed 4 companies: Sweetie Private Limited Company, Cutie Private Limited Company, Naughty Private Limited Company, Puppy Private Limited Company. In first company, 100 shares are there. 1 share is given to employee. 99 shares are with Dinsha. In second company, 100 shares are there. 1 share is given to employee. 99 shares are with Dinsha. Like that. Then later, he transferred Infosys shares to Sweetie Limited, Reliance debentures to Qt, and SG Limited shares to Naughty, and Wipro debentures to Puppy. So now his investments are zero. His income will be zero. And first company is getting 10k income, exempt to 10k, taxable 0. Second company income 10 no, exempt 10 no, payable 0. So he is transferring the investments in such a way that the income of each company should be within the exemption limit. Later, every company is conducting the general meeting. Which meeting? General meeting, and passing the resolution. Passing the resolution to transfer that income to Dinsha as a pretended loan. So who's transferring the income, beta? So all the companies are transferring the income to Dinsha as a pretended loan. What is the date of repayment? Don't know. What is the rate of interest to? Don't know. So these companies are transferring the income to Dinsha without any interest, without any repayment period. Then income tax officer filed a case in Dinsha for non-payment of the taxes, evasion of the taxes. Dinsha said, my income will be zero, so that's why I'm not paying any taxes. Then, but income tax officer said his companies are having the income. Then Dinsha said, yes, I am different, my companies are different, you can ask my company to pay tax. Then, then Judge Uncle said, hey Dinsha, how many companies you formed? 4 companies. Do they have any business? No. Do they have any factory? No. Do they have any employees? No. Do they have any office? No. Then why these companies are formed? Just to divide the income and avoid the payment of the taxes. Court is lifting the veil between the Dinsha and companies formed by Dinsha by treating both are one and the same. Done. Clear? Clear? And then we discussed one more case, beta. That is the Guilford Motors versus Honey. Guilford Motors versus Honey for the prevention of fraud and improper conduct. You can keep 1 to stars. This was asked 2-3 times in the exam. So there was a company called Guilford Motors. Which motors are? Guilford Motors. So in that company there was a MD who is in Honey. When Honey is employee, Honey is the employee and MD of the company. So one finally Honey is retiring from the company. When he is retiring, there was an agreement between the Guilford Motors and Honey. As per the agreement, after retirement, Honey can do any business, including similar business of Guilford Motors, but he should not solicit the customers of Guilford Motors. Then Honey, with help of his wife and friend, formed a company, Honey Private Limited Company. This company started soliciting the customers of the Guilford Motors. Guilford Motors filed a case. It was held that the main purpose of formation of the company by Honey is to solicit the customers of the Guilford Motors without making the breach of contract. Court is lifting the veil between the company formed by Honey and Honey by treating both are one and the same. Because the main purpose of formation of the company by Honey is to solicit the customers of the Guilford Motors without making the breach of contract. Then we discuss the next case law to decide the enemy character of the company, Daimler versus Continental Tire and Rubber Company Limited. What was happening in this case law? Some of the Germans went to England. In England, they formed a company called Continental Tire and Rubber Company Limited. In England, there was another English company, Continental Daimler Company Limited. See, some of the Germans went to England. In England, they formed a company called Continental Tires. In England, there was another English company formed by English people, Daimler Company Limited. What Continental will do? They manufacture tires in the England. They sell in the they manufacture tires in the Germany. They sell in the England. So, but Continental and Daimler both are formed in England only. After sale of the tires to Daimler, Continental sold the tires to Daimler on trade basis. After making the sale, before making the payment, there was a world war. As per the world war, Germany and England are the enemy countries. And Continental argues that since we both belongs to same company, same country, there is no concept of alien enemy. But Daimler argues that your members are from Germany. Yes or no, sir? But quote, Continental argues that I am different, my members are different between them. Corporate value is there. Yes, I am an English person, but member is a Germany person. The court held that the main purpose of the alien enemy is enemy country should not get the benefit from our country. If Daimler makes the payment to Continental transfer the money to Germany itself because all the shareholders employees are from Germany. Court had lifted the veil between the company and shareholders by treating both are one and the same. During the war, before the war, veil will be there. After the war, veil will be there. During the war, veil will be lifted. And next, subsidiary company acting as the agent of the holding company. Subsidiary company acting as the agent of the Merchandise Transport Limited versus British Transport Commission. What was happened in this case? So there was a transportation company. They have transportation violations. Because of the violation of the rules and regulations, the transport license of the company is cancelled. Yes, sir, no, sir. Company formed a subsidiary company. Company formed a subsidiary company applied to RTO for the license, but license was not granted to subsidiary company. Then subsidiary company was asking why you are not giving the license. Then RTO said your shareholder is a bad boy. Then subsidiary company said yes, my father is bad boy. You cancel their license, but I'm a good baby. Yes sir, no sir. Clear beta. But court held that license to subsidiary is nothing but license to holding itself because subsidiary doing the same business of the parent company. The court is lifting the veil between the holding and subsidiary by treating both are one and the same. Then we discussed one more case, beta. Smith Stone Knight versus Birmingham Corporation. Shareholders acting as the agents of the company. So there are three antisocial elements of the Smith Stone Knight are the antisocial elements who will work against the society. So they are prohibited from doing the business in the locality. They formed a company, also formed a private limited company. This company applied to license, but license is not granted by the GHMC. Yes sir, no sir, government is not granting the license. Then companies are asking why you are not giving me license. Government said your shareholders are bad. Then company said yes, between me and my shareholders corporate deal is the shareholders are bad, they are prohibited, but I am a good baby. Yes sir, no sir. But court held that your brain is nothing but your shareholders' brain. License to this company is nothing but license to the shareholders itself. Court is lifting the veil between the company and shareholders by treating both are one and the same. And then we discussed one more case to check the avoidance of the welfare legislation, that is workers of Associated Rubber Industries Limited versus Associated Rubber Industries Limited. So company said to employees work more. If you work more, we'll get the more money. So along with salary, I'll give you dividends. Yes sir, no sir. Bonus I will give you. In order to avoid the payment of bonus to workers, company formed a subsidiary company, transfer all the incomes to the subsidiary company in the form of the investments. So they're showing the zero to pay the bonus. The court held that the main purpose of formation of subsidiary company is to avoid the payment of bonus to workers. The court is lifting the bill between the company and the subsidiary by treating both are one and the same. Done. And then we discuss the statutory exceptions better. Reduction of the number of members below statutory minimum, very, very important. As per section 3 of the Companies Act, every public limited company should have the 7 subscribers, private company 2 subscribers. If number of members reduced below 7 and 6 after 6 months, after corporate will be lifted by treating both are one and the same. And existing members will be liable if they have the knowledge. If they are ignorant, they will not be liable. Then we discuss one more heading, fraudulent trading. ये भी important बेटा. During the winding up of the company, if it is found that the main purpose of formation of the company is to defraud the creditors, then will be lifted between the company and the promoters by treating both are one and the same. Then with this, we done with the revision of the chapter 1. Remaining part we will discuss in the next class. So, welcome back, sir. Welcome back to the world of law. So, we'll revise the next chapter, rapid revision. That is the types of companies from the company set. The beauty of this chapter, the whole chapter is 10 stars. Star, star, superstar, star, star, 10 stars. So, everything is important from this chapter, beta. The companies are basically how many types? 1, 2, 3, 4, 5, 6, 7, 8 types. How many types are? 8 types. 8 types of classification is there. So, on the first one, companies based on incorporation. That means how companies are taking birth in India. Company takes birth in India 3 ways. Incorporated company, started company, and a chartered company. And based on number of members. Based on number of members, companies are of 3 types. Public company, private company, and OPC. Public company 0 stars, private company 5 stars, and OPC 10 stars. 3 to 5 stars and 10 stars. Based on controlling, who is having the control over the company? Is 3 types: holding company, subsidiary company, associate company. So holding company 0 stars, subsidiary company 5 stars, associate company also 3 to 5 stars. Next, companies based on the liability. What is the nature of liability? 3 types: limited by shares, limited by guarantee, and unlimited company. Limited by shares and guarantee, you can keep 1 stars. He may ask difference between the limited by shares and limited by guarantee. And companies based on the ownership, who is the owner of the shares? 2 types: government company and non-government. Government company can keep 2 to 3 stars. And companies based on the listing, listed company and unlisted company. Unlisted company 0 stars, and listed company can keep 2 to 3 stars. Based on the nationality, 2 types: Indian company and foreign company. Foreign company 5 stars. Companies based on the other cases, section company 10 stars, illegal association 1 star, small company 10 stars, dormant company 1 2 stars, Nidhi company 1 star, PFI also 1 star. You can keep 1 star here. Done. So more or less every concept is very very important. Let us start. First one, companies based on the incorporation. How the companies are taking birth in India. Taking birth in India. 3 types: incorporated company and statutory company. Incorporated company, statutory company, chartered company. So what is an incorporated company? Incorporated company means which is incorporated under this Companies Act or previous Companies Act. Formed under Companies Act. These companies are governed by the Companies Act itself, like Satyam, Infosys, Reliance, SR, formed under Companies Act, governed by Companies Act. Next one is the statutory company. Statutory means as per law. Statute means law. Statute means law. So these are the companies formed under special act. Special act of central government or the state government, assembly or the parliament. So these companies are governed by the special act only. If special act is silent, then we will apply Companies Act, like LIC formed under LIC Act, SBA formed under SBA Act. So these companies accounts are maintained by C&AG, Comptroller and Auditor General of India. Generally, this kind of companies need not have the PBT entity as a part of the name of the company, LIC of India, but not LIC Limited. Yes sir, no sir. And these are found for the public utilities, that is to satisfy the needs of the society, but not to aim at the profits. They will make the profits, but profits they can't eat because ultimately owned by the government, like LIC, RBI, SBI. Chartered company. Charter means special order, special license, special power given by the king of the country or the monarch. These are the companies formed under the special order given by the king of the country or the monarch. The powers of these companies governed by the charter itself. They are famous in the 17th and 18th centuries in England. Example: East India Company, Bank of England are the chartered companies. This is not important from exam point of view. Second one, companies based on the number of members. Number of 3 types: public company, private company, and OPC. OPC, private company 5 stars, OPC 10 stars, public company 0 stars. Public company means a company which is not a private company, which is not a other than private company, which has the minimum capital as may be prescribed. There is no capital limits. However, a private company subsidiary of a public company deemed to be public company itself. So what is the meaning? See, the main purpose of the Companies Act is to give production to public money. Which money? See, one private company is there, beta. Gupta Private Limited Company. And one public company is there, beta. Srinath Limited. Srinath Limited. Public is investing in the Srinath Limited. Srinath is investing in the Gupta Private Limited company. So ultimately, indirectly, in this private company, whose money is there? Public money is there. It is a private company, subsidiary of a public company. In this private company, public money is there. So we should treat this private company as a public limited company itself because public money is involved. A private company, subsidiary of a public company is deemed to be public company itself. Done. Next, private company. Which company? Private company. Section 2, clause 68, 5 stars. Private company means a company which has the minimum paid up share capital as may be prescribed and by its articles of association. So in private company, so minimum capital is required. How much you not specified in the company sector. And in its AOA, there must be 3 restrictions. How many restrictions, sir? 3 restrictions. First restriction restricts the transferability of the shares. Yes, we can sell the shares as per the AOA restrictions. We should not sell Gado. We can sell, but as per the AOA. In this class, 100 students are there. Out of 100, 10 students form the private company. Yes, then we can sell the shares. Only remaining 90. Only remaining 90 out of 100, 10 form the company. We can sell, but only remaining 90. So restricts the transferability of the shares except OPC. Why this word is there? Every private company is deemed to be, every OPC is deemed to be private company only. But for OPC, this clause is not applicable. For OPC, this clause is not applicable because OPC is a private company only. So except OPC, the maximum number of members can be 200. In a private limited company, maximum number of members can be 200. While counting this 200, we should not count the present employees, past employees. Who become the member because of employment? Member is not purchasing the share. So one of the employee, company is impressed by the performance of the employee. Company giving the free shares to any employee. Company is giving which shares, sir? Free shares. So present employees, past employees, to whom company giving the free shares, employee stock options, ESOPs, they should not be counted in this 200 present and past employees who become the members because of employment should not be counted, and joint shareholders count as a single member. Sweetie Cutie Naughty jointly purchased 1 share. Sweetie Cutie Naughty jointly purchased 1 share. They are not 3 members, they are only 1 member. And prohibiting the invitation to public for subscription of the securities. Prohibiting the public. So this is restriction on the existing shares. Restriction on the transfer of existing shares. If private company is giving a new shares, the new shares can be given only to members, directors and their relatives only. Members, directors and their relatives only, but not the outsiders. This is secondary market, this is primary market. Secondary market and the primary market. 3 restrictions. Restricts the transferability of the shares, limits the number of members to 200. In this 200, don't count the present employees, past employees, joint shareholders as a single member. And if private company giving the fresh shares, the fresh shares can be given only to existing members, existing directors, and their relatives, but not to outsiders, but not to general public. So private company and the public company. Next one is the OPC, 1% company. Which company? 10 stars are there, beta. What is the OPC? OPC means a company which has a single person as a member. Single person as a. If that guy is there, he will take care of the company. If he dies, if something happens to that guy, that should be how to specify the name of the nominee. So every private limited company should have every OPC should have the minimum capital as may be prescribed. So if something happens to member, nominee will enter into picture. So before appointing any person as a nominee, we should take his written consent. That consent also should be filed with the ROC in form number INC 3. So nominee may withdraw his nomination. So nominee may withdraw his nomination. Member can change the nominee. So if member is removing or nominee is withdrawing, there is a vacancy in the nominee. The vacancy in the nominee should be filled within the 15 days. If there is any change in the MOA and AOA, it must be filed with the ROC within the 6 months. It is deemed to be private company itself. Because of change of the nominee, just because of nominee changing, it is not deemed to be alteration of MOA and the AOA. So very important point, beta. Who can become the nominee? If you want to become the nominee or member of the OPC, the person must be natural person, citizen of India, resident of India. 3 conditions. He must be natural person, citizen of India. He may be resident of India or not. Important. Resident or Not. Resident means who staying more than 120 days in the previous year, financial year. So he must be natural person, he must be citizen, he may be resident or he may be non-resident also. Single person can form only single OPC. Minor cannot become the member, minor cannot become the nominee because he is incompetent to enter into contract. So OPC cannot be NPO, OPC cannot be NBFC, cannot be NBFC, and we have to write the words one person company within the brackets under the name of the company. It must have minimum one director. It cannot be 69 company, it cannot be NBFC also, non-bank financial corporation. Next, companies based on the control, holding company, subsidiary company, and associate company. 5 stars, 0 stars. What is holding company? A company said to be holding company if other company is subsidiary. That's it. I said to be faculty if you are a student. Yes sir, no sir. In the same way, what is the meaning of subsidiary company? A company said to be subsidiary company if it satisfies 2 conditions. How many conditions, sir? First, company. Holding company controls the composition of the BOD, board of directors. Composition means mixture. Composition means mixture. For example, one company is there, beta. Small company. Which company? Small company. In small company, 10 directors are there. Out of these 10 directors, big company only appointing and removing more than 5. 7 directors are appointing, 7 directors are removed by the big company. Big company will become holding company, small company will become subsidiary company because other companies controlling the composition. I will decide the directors of your company. Yes or no, sir? Follow. And holding company controls more than half of the total voting power. Total voting power. So there is a small company, there is a big company. In small company, 100 shares are there. Out of 100 shares, more than 50, 60 shares are held by big company, holding company, and small company. So very important. This condition is very important based on the so many examples are there in the exam. So holding company controls more than half of the voting power either on its own, either with one or more of subsidiaries. We discuss the examples. There is a company A company, there is a company D company. In this D company, out of 100, A is having the 70 shares, holding and subsidiary. There is a company A company, there is a company B company, there is a company C company. B and C are subsidiaries of A. A is the holding, B and C are the subsidiaries. There is a company called D company. A company, D company. D company having the 100 shares. Out of 100 shares, B is having the 30, C is having the 40. Pura milke 70. So whether A become the holding of the D? Yes. Because A directly holding 0 shares, indirectly holding the 70 shares in D company. This example came in the exam more than 10 times. Same company, same example. Either on its own and together with one or more its subsidiaries. So a company said to be a subsidiary company if holding company controls the composition of the board directors. Holding company controls more than half of the total voting power. And this section 19 also very important. Beta exam mein aa raha beta. Subsidiary company should not have the shares in the holding company because who is giving the money to subsidiary company? Holding company only. So subsidiary company should not give the money to holding company. There is a company called big company, holding company. There is a company called small company, subsidiary company. It's a holding company, it's a subsidiary company. So subsidiary company having some shares, whose money is that? Big company money only. Subsidiary company should not have shares in the holding company. Done? Clear? But 2 exceptions are there, beta. Subsidiary company can have shares in the holding company. Subsidiary company having the shares in the holding company as the legal representative or the trustee of third party. We discuss one example. तो कौन है बेटा? ताता. वो कौन है? ताता. ताता. So shareholder of the big company. Tata mar gaya. Tata mar gaya. The shares are given to Chintu. Chintu is a minor. So Tata is the shareholder of the holding company. So can Chintu become the shareholder? No, because he is a minor. So court is appointing the trustee. Court is appointing the trustee. So who is the trustee? Small company. Here small company having the shares in the holding company as a benefit for the benefit of the third party. Allowed? Allowed. And subsidiary company becoming the shareholder before it becoming subsidiary. So subsidiary purchase some shares in the holding company. When before it becoming subsidiary, that will not be affected. That will not be done. Clear. And whether we should surrender the shares, not required. We need to surrender the shares also. Next one is the associate company. A company is said to be associate company if other companies having the significant influence. Significant influence means right to control 20% of the voting power. Which power? 20% or more of the voting power. More than 50, subsidiary. More than 20, less than 50, associate company. Which company? So there is a company, big company, there is a company, small company. So small company having the 100 shares. Out of 100 shares, big company is having the more than 22 shares. It becomes holding, it becomes associate company. Which company? Associate. More than 20, less than 51. Done. Clear na beta? Next concept will be companies based on the liability. So next types of shares will be, next type of companies will be companies based on the liability. These are three types: limited by shares, limited by guarantee, and unlimited company. First of all, what is a company limited by shares? If it is a company limited by shares, the liability of each shareholder will be maximum to the extent of unpaid amount on the face value, including premium if any. This unpaid value can be called by company during the life of the company or the winding up of the company. Yes, I know, sir. These are the famous type of companies in the real life. For example, face value of the share is 10 rupees, issue value of the share is 10 rupees, paid up value of the share is 7 rupees. What is the unpaid value? 3 rupees. So the liability of shareholder will be maximum to the extent of unpaid amount on the face value, that is the 3 rupees. For example, if company is issuing the shares like this, face value 10 rupees, issue value 12 rupees, 2 rupees premium, paid up value 8 rupees. Your liability will be maximum 4 rupees. Unpaid amount on the face value including premium if any. Next, company limited by guarantee. Limited by guarantee. See, if it is a company limited by shares, the liability of each shareholder will be unpaid amount on the face value including premium. So, in other words, during the existence of the company or winding up of the company, we can call it unpaid value. They are the most famous type of companies in the real life. Yes or no, sir? Next, company limited by guarantee. So, guarantee companies have two types: pure guarantee company, guarantee plus share capital. Yes or no, sir? So, if it is a guarantee company, it may have share capital, it may not have share capital. The guarantee amount can be called by company only during the winding up of the company. The AOA of the company has to specify the number of members in which company is incorporated and the amount of the guarantee. And this amount can be called except during the winding up of the company. Generally, guarantee companies are incorporated as NPOs to promote the arts, science, commerce, religion, charity, sports, education, but not to make the profit. Since members will pay the money only during the winding up of the company, this kind of companies will get the initial capital in the form of donations, subscriptions, entrance fees, and endowment fees, etc. Yes, sir, no, sir. Next one is the unlimited company. Which company? Unlimited company. So it is a company without having any limit on the liability of the member. Unlimited liability will arrest member only during the winding up of the company. So it may have come as per section 292, company can be formed with liability or without any limit on the liability of the member. Company not having any limit on the liability of the member. No limit on the liability of the member during the winding up of the company. It may have share capital, it may not have share capital. And the AOA of the company has to specify the amount of the share capital and number of members with which it is incorporated. Until the company can convert into limited company by passing the special resolution. So liability of the members before conversion will be unlimited, after conversion will be limited. Yes sir, no sir. If company is unable to pay, the members liability will become unlimited. Company is unable to pay means winding up of the company. Then this one is important better. Limited by shares versus limited by guarantee. He may ask in the exam. Next term, company is based on the nationality, Indian company and a foreign company. First of all, what is an Indian company? Indian company means a company which is registered in India, which has a place of business in India, which is registered in India. India में पैदा हुआ. They doing the business also in India. It is said to be Indian company like Tata. Tata registered in India, doing the business in India. So it is an Indian company. Which company? Next one is a foreign company, 5 stars. How many stars? 5 stars. Star, superstar. So they may do the business in India. But is a foreign company which is registered outside India. Registered, for example, Microsoft Computers incorporated outside India in the America. They have the place of business in India. Registered outside India, place of business in India. Place of business means office, warehouse, or any other premises from which it is doing the regular business activities. They may do the business in India either on its own or through agent, either physically or electronically. I can just ask for the electronically because that thing will test in the exam. So which is registered outside India, which has place of business in India. Place of business means office, warehouse, or any other premises from which they are doing the regular business activities with some visible indications. They may do the business in India either by itself through agent, either physically by opening a shop or electronically like Amazon. So this thing is very important. Then so Indian company and a foreign company. Next one is the hmm, listing based on the listing. So based on the listing comparison of two types, listed company and the unlisted company. What is the meaning of the unlisted company? Unlisted company means which is not a listed company, which is not a listed company. What is a listed company? If you go to NSE, if you go to NSE and BSE, there are two recognized stock exchanges are there in India, NSE and BSE. So this is important. Two stars. NSE, BSE. Outside the NSE and BSE, if you go to railway station, outside the railway station, they will keep a board which train is coming and which platform. They will keep a board, no, beta. So few train names will be there. In the same way, National Stock Exchange, है ना? One list will be there. Tata, Reliance, SG Limited, Infosys, ऐसा है ना sir? So whoever names are there in the list, उसको बोलते हैं listed company. For example, Satish Limited is there. Which limited? Satish. His name is not there in this list. Satish company shares cannot be purchased and sold in NSE. You can sell outside market. Unlisted company. Which company? Listed company means a company whose shares are listed with the recognized stock exchange. That is NSE or BSE. See, once shares are listed, the shares should be only in dematerialized form. That means electronic form of the shares. There will not be any physical shares. If the company is listed, if it is an unlisted company, we may have physical shares. Listed means pakka electronic shares. See, this is very important, sir. This is very important. Shares means only equity shares. Shares means only, but not preference, but not debentures. Companies that they're listing the preference shares. Is it listed company? No. Listed debentures. Is it listed company? No. They're listing the equity shares. Is it listed company? Yes. So if they're listing, see, equity share is like a son, preference is like a daughter, debenture is like a outsider. They're listing the equity shares. It is a listed company. Listing only preference shares, not a listed company. Listing only debentures, it is not a listed company. This was asked so many times in CA Enter also. Done? Clear? Yeah. Next, companies based on the ownership, government company and non-government company. But it's non-government company, which is not a government company, like ITC, Tata, Reliance, which is not a government company. Government company. What is a government company? Five stars. In which not less than 51%, not less than 50.5% shares are there. Listed government one company is the SG Limited. In this SG Limited, 50.5% of the shares are held by the government of Telangana. Listed or unlisted? Government or non-government? Non-government. It means 51, 51 or more, not 50 plus. It is 51. Subsidy company 50 plus, more than half, more than 50.1 also more than half only. 51 is different to 50.1 is different. 50.1, 50.2, 50.3, 50.4, 50.5, 50.6, 50.7, 50.8, 50.9, then 51. More than half is different to 51 is different. In this company, SG Limited, 100 shares are there, 1000 shares are there. Out of this 1000, 50.1% shares held by the government of Telangana. Is it government company? No. 50 plus is different, 51 is different. 50 ki 51 ki 10 points unta madhyala. Aisa, he's asking like the depth of the questions super crazy. He's testing you whether your understanding difference or not. 50 plus 51. Holding subsidy దగ్గర more than half, more than 50.1. Also holding subsidy. Here 51, more than 50. ఏమంటుండు? Not less than 51%. Not less than. Both are different. This kind of things he's testing in the exam. So the depth of the questions he's asking in the exam. So a company in which not less than 51% of the capital held by central government, a state government, or jointly. Subsidiary of a government company is also government company. For example, there is a company called BHEL, Bharat Heavy Electricals Limited. Out of 100, 70 shares are held by central government. Yes sir, no sir. So it's a government company. Which company? Government company. When companies are SG Limited, SG Limited 100 shares are there. Out of 100 shares, 60 shares are held by BHEL. So SG Limited also government company. Then yes sir, no sir. Subsidiary of a government company is also government company. Who will do the audit of government company? CAG. C and DG will do the audit. Audit report will be placed before the both the hosts of parliament because they are the owners of the company. Then next one is the section 8 company. So many stars. How many stars? Very important. So if the limited company, which company? Limited company can able to satisfy the ROC that the main purpose of formation of the company is not to make the profit but to serve the society, to promote arts, science, commerce, religion, charity, sports, education, environmental production or any other social cause. Then ROC will give a special license under section 8 to give the privileges, advantages and non-applicable to the provisions of the Companies Act. So being a section 8 company, it should utilize the income profits only to promote the objective, but not for the purpose of distribution of the dividend. So it must prohibit the payment of dividend. Prohibit the payment of the dividend. I kept stars. If they're having any income, will they have any profits? Yes, crores of rupees. We discussed example also, good example. So they have to utilize the profits only for the purpose of promotion of the objective. They should prohibit the payment of dividend. So ROS will give a special license under section ITA. So this kind of company need not have the LTD, PBT, LTD as a part of the name of the company. That bundle is not required. So ROS will give the privileges, advantages non-applicable to the provisions from Companies Act. Even a firm can become a member. Generally, partnership firm cannot become a member. Partners can become a members, but not the partnership firm. But in section 8 company, even firm can become the member. And this kind of company should not enter the objective class without the consent of the ROC. This kind of company can convert into profit-making company by passing the special resolution. By passing as the section 8 company can convert into profit-making company. Generally, this kind of company should not enter the objective class of MOA and AOA without the consent of ROC. And RT will revoke the license. Regional director will revoke the license if the company is contravening this section, contravening the fundamental conditions for which license is granted, companies acting fraudulently, companies acting opposite to public. So if a company is acting opposite to society, if the company is acting fraudulently, if the company is contrary the fundamental reason for which license is granted, and company is acting contrary to this section. For example, company giving the dividend contrary to this section. License is given to promote the arts, but they're manufacturing the bombs. If the company is acting the fraudulently, taking the donations from the people, eating trustees are eating that money. So in these 4 cases, RT will revoke the license after providing the reasonable opportunity of being heard. After revocation of the license, RT may order for addition of the words PBT, LTD or LTD as a part of the name of the company. RT may order for amalgamate with another section 8 company having the similar objective. RT may order for winding up of the company and transfer the assets to another section 8 company having the similar objective. When I'm keeping a stars on few points, that points are tested in the exam. आरा क्या आ रहा कुछ भी नहीं आ रहा keep the stars. So Satish Charities is there to promote the arts. The license is cancelled. Then Satish assets should be transferred to SG Charities because same purpose, that is to promote the arts. SG Charities is there, Satish Charities is there. His license is cancelled because of violations. They are promoting the arts. I am also promoting the arts. After winding up of this company, transfer the all assets to SD charities. And RD may order for the penalty for the company 10 lakhs rupees to 1 crore. Penalty for officers of the company imprisonment up to 3 years or 25,000 rupees to 25 lakhs rupees or both. But in case of the fraud, the promoters of the company, directors of the company punishable under section 447. What is 447? 447 again three types. If the fraud amount is less than 10 lakhs or 1% of turnover, fraud amount is less than 10 lakhs, 5 lakhs fraud, 6 lakhs fraud, small amount. Less than 10 lakhs or 1% of the turnover. So, imprisonment up to 6 months to 10 years or fine thrice the amount of involved. Sorry, and is there. If the fraud amount is involves upward to public, if that's because of the fraud, society is affected. Imprisonment up to 3 years. If the fraud amount is sorry, this is at least 10 lakhs, more than 10 lakhs, more than 10 lakhs. Fraud amount is less than 10 lakhs and 1% of turnover of the company. Imprisonment up to 5 years or fine 50 lakhs rupees are the both. This fraud amount is above 10 lakhs, below 10 lakhs, up to public policy. Then 447 is a penal section. Only penalty will be there. Next, illegal association, you can keep 1 star. If there is any illegal association, if there is any association or any partnership having more than 50 partners, it must convert as a company under company sector, company under any other special act. Then, otherwise, it is said to be illegal association. But two exceptions are there: HUF and professional partnership. Even number of partners exceeding 50, HUF is not illegal and partnership is not illegal. Effects of the illegal association. Illegal association cannot enter into contract void of initio. Illegal association cannot sue the member. Member cannot sue the illegal association, and each member is punishable with a penalty up to 1 lakh rupees. And next one is the small company. Very important. Small company means a company other than public company. Other than it must not be public company. It may be private company. However, capital should not exceed the 10 crores. Capital should not exceed the and turnover should not exceed the 100 crores. A plus B, both the conditions must be satisfied. And following companies cannot get the license under section 285. Holding and subsidiaries cannot be small company. Section 80 company cannot become small company. Company formed under special act cannot be small company because the main purpose of small company is to do the exemptions. So holding subsidiary relationship is that you are not a small company. And section 80 company already gave you so many exemptions. We don't want to give you again. And company formed under special act governed by special act only. Next one is the dormant company. Dormant company means inactive company. Dormant means inactive, not regularly performing the activities. So dormant company means a company which has not been carrying on any business or operation, which is not having any significant accounting transaction, which has not filed finance statements with ROC during the previous 2 years. So what is dormant company? Not having any business or operation, not made significant accounting transaction during the previous 2 years, not filed the finance statements annual returns with ROs during the previous two financial years. Is said to be dormant company or the inactive company. Nidhi company is kind of a chit fund. Is like a chit fund. It will accept the deposits only from the members, give the loans only to members. इसको बोल के निधि company you can keep 1 stars 1 to 10 star बेटा. निधि company means which was formed with the objective of promoting the savings among the members, receiving the deposits from members, giving it to its members only. The main purpose is to develop the savings among the members. And which public financial institutions, PFI. Right now, only PFI is there in India, that is LIC of India. What is that? LIC. LIC of India or any other company notified by Unit Trust of India, any institution notified by central government, any institution notified by central government and RBI. When UTI, CG and RBI will notify an institution as the PFI. CG, RBI, UTI may recognize an institution as a PFI if it is formed under the Central Act or State Act, not less than 51% of the capital held by central government or the state government or jointly. And then government may treat you as a PFI. So with this, we have done with the revision of the other companies. So remaining part we will discuss in the next class. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. So welcome back, sir. Welcome back to the world of law. Let us revise the rapid revision of the chapter 3 of the Companies Act Incorporation. Bolo? So what is the meaning of incorporation? So we discuss one example. One fine day. When? Where is our Dhirubhai? चले गया. So, Dhirubhai Ambani. Which Ambani? Was getting the idea. Was getting the idea to start the business. To start the business. RIL. तो धीरूभाई को बोलते हैं प्रमोटर. ए मोटर प्रमोटर. So promotion means getting the idea to start the business. Promotion means getting the idea. Promotion means preliminary activities undertaken by promoter to bring the company into existence. So to give the life to company, we should do some preliminary activities. That is said to be promotion. So promoter means general definition. Promoter means who is getting the idea, who is preparing the feasibility report, possibility report, profitability report. Is it possible or not to do this business? And who is getting the approvals from the appropriate government, who is preparing the MOA, AOA, who is identifying the financials, who is appointing the administrative staff, who is putting the documents with the ROC, who is obtaining certificate of incorporation. ऐसा काम करता है ना बेटा, उसको बोलते हैं promoter. The one who does all these activities is deemed to be promoters. Then there are 4 stages are involved for formation of the company. First one is the promotion, next one incorporation, next one flotation, last one is the certificate of commencement of business. We will discuss this thing in the CA inter or CA final. Inter. Done na beta? So all these things are not there at foundation level. First one promotion. Promotion means idea, getting the idea to start the business, to form the company, private company. There must be minimum of the 2 subscribers, public company 7 subscribers, OPC 1 subscriber. When it comes to definition of the promoter, this was asked once in the exam beta, I think 14 or 15. So promoter means a person who is named as such in the prospectus of the company. Company is issuing the prospectus. In the prospectus, I wrote Gopal is the promoter. Then he is a promoter. And who is identified by annual returns. Annual returns means every year company has to put some information to ROC. In the annual returns, I said Shruti is the promoter, then she is deemed to be promoter, who has the control over the affairs of the company, either as a shareholder, director, or otherwise. So if I have the control over the activities of the company, I am said to be promoter. According to whose advice, directions, instructions, the BOD of the company accustomed to act. BOD of the Reliance will act as per my wish. I deem it to be promoter. As per the wish of the wish person, so the BOD is acting. The person is deemed to be promoter. Promoter can be, however, this is important beta. Important. This is asked in CA enter, CA foundation. I don't know. CA enter. This was asked. So professionals acting in the professional capacity are not the promoters. CA, CMA, CS, advocate. So who will do the professionals? Who is providing the professional services are not deemed to be promoters. Then clear. Next, promoter can be artificial person. Promoter can be natural person. For example, Dhirubhai Ambani, natural person who is forming the Reliance. Reliance is forming Reliance Fresh. Who is the promoter of Reliance Fresh? Reliance itself. Yes sir, no sir. Promoter can be natural person. Promoter can be artificial person also. Next stage is the incorporation, stage 2. That is the formation of the company. Procedure for formation of the company. So before formation of the company, first we should decide the type of company to be incorporated, whether to form the private company, a public company, a OPC, a limited company, unlimited, limited by shares, limited by guarantee, both are profit making, not to make the profit. This is what we should decide. For example, we want to form the public company, limited by shares to make the profits. So after deciding the type of company to be incorporated, we should decide the name of the company. The promoters of the company has to make an application to CRC department of the ROC, Central Registration Center. CRC means Central Registration Center. It's a department in the MCA, Ministry of Corporate Affairs. So we have to make an application to ROC for reservation of the unique name. The name of the company should not be similar to already existing company name, brand name. So the name should be unique. Reservation of unique name. It is known as the RUN. RUN means reservation of unique name. So we have to make application to CRC department of the MCA. Done. So after getting the name, we have to prepare the MOA and the AOA. MOA is the primary document of the company which contains the objectives of the company. We have to prepare the AOA. It is secondary document of the company which contains the rules and regulations for management of the company. And MOA, AOA should be in form number 33 and 34. MOA should be form number MCA 33. AOA should be in form number AOA, INC 34. INC means incorporation. These form numbers. In this form, we have to file the MOA, AOA. And we have to give declaration to ROC. ROC. We are the promoters of the company. We are directors of the company. We are good people, but not the bad people. So who has to give declaration on promoters and the first directors? They have declared that they have not convicted for any offense. Conviction means jail. So they have not convicted for any offense for formation, promotion, and management of the company. They have declared that who has to declare promoters and first directors. They have not found guilty of the fraud, misdemeanor, breach of duty. We are not doing any fraud. We are not doing any misbehavior. We are not doing any breach of duty under companies during the previous 5 years. And all the documents filed with the ROC contain the true, correct, and complete information to the best of their knowledge and belief. So we are filing a lot of information. It contains the true information, but not the wrong information. They have declared. And till company getting its registered address, we have to give some temporary address to ROC for the purpose of communication. Generally, address of the promoter. Then we have to file the particulars of the promoters with ROC. So we have to give the particular name, surname, family name, residence address, nationality with the ROC. For example, my name Potuganti Srinath Gupta. Name Srinath Potuganti, surname Gupta, family name, and my address, my nationality should be filed with the ROC, and particulars of the first directors. So we have to give the name, surname, family name, DIN number, residential address, nationality of the first directors with the ROC. And we have to take the written consent of the first directors. So proposed first directors has to give the written consent that they are not disqualified under Companies Act. They are willing to become the directors after formation of the company. And next one is the address for registration. Every company should have the registered address within 30 days of incorporation. We have to invite the registrar for verification of the address within the 45 days of incorporation. Then after that, we have to promoters have to go to CA, CMA, CS or advocate into practice. So the CA, CMA, CS or advocate into practice has to certify that promoters followed the procedure prescribed under the Companies Act for the formation of the company lawfully and legally. Company पैदा होने के लिए क्या क्या करना जो कर दिया promoters done. He has to give certificate. ये पूरा certificates पकड़ के we have to go to ROC along with filing fees and registration fees. Registration fees is based on the authorized capital, more fees. If company is not having the capital, it is based on the number of members and guarantee amount. If registrar satisfies with the documents filed with him, he will issue the certificate of incorporation. So happy birthday for the company. When certificate of incorporation is issued, company comes into existence. Company has to maintain the certificate of incorporation till the winding up of the company. When certificate of incorporation is issued, subscribers will become members. Company will become body corporate, that is artificial person. Company can enjoy the features like perpetual existence, common sale, right to acquire the property, capacity to sue, capacity to be being sued. All the features will be getting the company. And this one is important, beta. Effect of giving a wrong information. You're filing lot of information with the ROC for formation, but you're giving a wrong information. If company is not incorporated, registrar identified the wrong information, he will not allow for the formation of the company. Promoters are punishable under section 447. What is 447? Penalty for the fraud. Company registered already. After registration of the company, registrar identified that they gave a wrong information for formation. Then registrar will forward it to NCLT. NCLT means Special Court under Companies Act. National Company Law Tribunal. ट्रिब्यूनल मीन्स स्पेशल कोड अंडर स्पेशल एक्ट. अंडर कंपनी सेट वन कोर्ट इज देयर, उसको बोलते हैं एनसीएलटी, नेशनल कंपनी लॉ ट्रिब्यूनल. ट्रिब्यूनल में ऑर्डर फॉर द रेगुलेशन ऑफ द मैनेजमेंट, चेंज इन द डायरेक्टर्स एंड alteration of the MOA and AOA. So change the objective of your company. Your company objective can be sugar but not brown sugar. Yes sir, no sir. And liability of the members will become unlimited. ROC may order for the removal of the name of the company from the register of companies. ROC may order for the winding up of the company. ROC may order, NCLT may order for any other order as deemed fit. Plus promoters punishable under section 447. That penalty is asking. Few businesses like banking, insurance requires the approval from the sectorial regulators. Sectoral regulators means, for example, insurance sector governed by the IRDA. banking sector governed by the RBI. If you want to do the banking business, you have to get the approval of the RBI. If you want to do the insurance business, you have to get the approval of the IRDA. So that approvals also you have to obtain before formation of the company. And next concept is the SPICE. SPICE means simplified proforma for incorporation of the company electronically. Instead of filing the documents physically, you can also file all these documents from the www.mca.gov.in. Then इसको बोलते हैं SPICE. So ROC will issue certificate of incorporation in form number INC 11. Done na beta? Clear? So once ROC satisfies, they will issue certificate of incorporation like this. This is a format. Done? Clear? So remaining part we'll discuss in the next class. So in the next class we'll do the scanner. So welcome back to the world of law. Welcome back to the world of SG. Let us revise the MOA and AOA. We'll do rapid revision. First of all, what is the meaning of MOA? So we discuss one example. See, we see this world with our two eyes, two eyes, left eye and right eye. Company will see this world with it two eyes. So one eye is MOA, one eye is AOA. Company will see the external world with eye is known as MOA. Company will see the internal world with eye known as the AOA. MOA is for outsiders. MOA is for the outsiders. AOA is for the insiders. MOA contains the objectives of the company, powers of the company, scope of the company. AOA contains the powers to achieve the objectives. AOA contains the powers of directors, officers, and shareholders. Yes or no, sir? So MOA will contain the 5 clauses, 6 clauses. Name clause, situation clause, objective clause, capital clause, liability clause, and the subscription clause. And in case of the AOA, it will contain the rules and regulations for the internal management of the company. So my father kept a board outside the gate. This is my home. This is my house. My father kept a board outside the gate. It will contain name of the family, Podugandi family, 2 days, 3 days, 4 days, Godapalli, Hyderabad. Situation is a rice merchant. ऑब्जेक्टिव क्लास सो इसको बोलते हैं MOA. क्या बोलते हैं इसको? In the hall, inside the home, in the main hall, है ना? He's keeping a one more flexi. He said in the rules and regulations to stay in the home. You got to wake up on time. How should I call my brother? How to solve the disputes? What I should do? What my brother should do? What my mother should do? All his things is writing. इसको बोलते हैं AOA. It is for the smooth functioning of the organization. It contains rules and regulations for the internal management. Then so when it comes to MOA definition, beta, MOA means MOA of the company. MOA means which is originally framed at the time of incorporation of the company and which is altered later from time to time in pursuance with, in complying with the provisions of this company sector or any of the previous company law. Is said to be MOA. The definition, beta, as per section 256. But what is MOA actually? MOA is a charter of the company. Document. It contains the fundamental conditions for which company is incorporated. It contains the objective of the company. It contains the scope of the company. It's a primary document of the company. So, objective of Philips, manufacturing of the lights. Objective of the Ahuja, manufacturing of the mics. Objective of the Tupperware, manufacturing of the bottles. Objective of the American Tourister, manufacturing of the bags. So it is a charter of the company, constitutional document. It contains the fundamental conditions for which company is created. It is contains the objectives and scope of the company. So every company has to register the MOA with the ROC. Once company it is registered with the ROC, it is deemed to be signed by each and every member of the company, and every member has to observe the conditions of the MOA, and amount specified in the MOA will become the debt due by member to company. Important beta. And this MOA will binding the relations between the company and the outsiders. Once company filing the MOA with the ROC, it will become the public document because ROC is a public office. This document will be available for the general public inspection. Every company must have the MOA. They can prepare their own MOA or adopt from the Schedule 1. In Schedule 1, Table A, it is the MOA of a company limited by shares. B, guarantee company not having share capital. C, guarantee company having share capital. D, unlimited company not having share capital E, another company having the share capital. It is a model form of MOA. You can adopt from the schedule 1. So MOA contains the objectives to be achieved by company after incorporation of the company, purpose which can be exercised to achieve the objective specified. And so the main purpose of MOA, it is information to shareholders and creditors how money will be utilized, what we will do with your money, and it is information to creditors and outsiders whether proposed contract is intra-virus or the ultra-virus. Then clear. And every company MOA should have the every company MOA should be printed, divided into paragraphs. They must be serially numbered. They must be stamped as per Indian Stamps Act. It must be signed by 7 subscribers in case of public company, 2 subscribers in case of private company, along with 1 witness. Opposite to signature, we have to specify name of the subscriber, address of the subscriber, occupation of the subscriber, and number of shares subscribed. And this will contain the 6 clauses. First one is the name clause, situation clause, objective clause, liability clause, capital clause, and subscription clause. In case of the nominee, we may have the additional clause known as the OPC. In case of OPC, we may have the additional clause known as the nominee clause. Which clause, beta? If the MOA is having any additional clause, it is given to be articles. So MOA should have only 6 clauses. In case of the OPC, only 7 clauses. If there is any additional clause, it is given to be articles of association itself. And when it comes to name clause, it explains how the name of the company is supposed to be. In case of the public company, the name of the company should contain the word LTD. In case of the private company, the name of the company should contain the words PBT LTD. LTD, PBT, LTD not required in case of the Section 8 company. However, the Section 8 company name should contain the words like foundation, forum, association, federation, chamber, confederation, council, electoral trust. Electoral trust means political party. Congress, BJP, or the electoral trust. So, Section 8 company name should contain these words. And government company name should contain the words LTD. SR BHEL, Bharat Heavy Electricals Limited. And in case of OPC, within the brackets, we got to specify the words one person company. The name of the OPC will be Srinath Gupta Private Limited Company. In the bracket, we have to write OPC. And next one is the situation clause. It defines the state in which company is registered. Hyderabad, Telangana, Tamil Nadu, Maharashtra. So it defines the state in which company is situated. It defines the place of residence or the domicile of the company. Then next clause is the objective clause, which is very, very important. Star, star, superstar, star, star, mega star, 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 5-star. So objective clause. So this clause contains the objectives to be achieved by company after incorporation. It is informing to shareholders how the money will be utilized. It contains the power of the company, scope of the company. Yes or no, son? This informs shareholders and creditors how money will be utilized. Why I have taken my birth? Why I have taken my birth? What is my objective? What I will do with your money is explained by the objective clause. Remember, this clause is giving the protection to investors and creditors because money invested by them should be used only for the objective specified in the memorandum of association of the company. Yes or no, sir? If the company using the money for any other purpose, it is deemed to be ultra virus. This clause developed a doctrine called as doctrine of ultra virus. This doctrine is using the money given protection to the money given by shareholders, money given by the creditors. Because we are not believing the promoters, we believe in their objective. They have to utilize the money only for the objective specified, but not for any other purpose. So this doctrine developed the doctrine called doctrine of ultra virus. Doctrine means theorem. Ultra means beyond. Virus means power. VIRES, not US. So there was a famous case la Ansbury Railway Carriage Iron Company Limited versus Ritchie. So this was happened in the country in the city called Belgium. In the Belgium, there is a lady called Ritchie and there is a person called Ashbury. What is the objective of the Ashbury? Mechanical engineering and general contracts. Ashbury company entered into contract with the what this company does? The main purpose of the company is laying of the railway track, supplying of the raw material, supplying of the wagons, making of the wagons, and renting of the wagons, supplying of the labor. This is a business of the company. That is a railway business. Railway tracks business. The company entered into agreement with the two contracts with Richel. One is the laying of the railway track in the Belgium, other one is the financing. Laying of the railway track is the intra-virus, but financing is the ultra-virus. Subsequently, this agreement was ratified by whole body of the shareholders. Later, the company refuses to give the money to Ritchie. Ritchie filed the case on the Ashbury. Ashbury argues it is beyond my objective class. But Ritchie argues, yes, it is beyond your objective class, but it is ratified by whole body of the shareholders. But Judge Uncle said, Amma Ritchie, ultra-virus activity cannot be ratified even by whole body of the shareholders. Then she filed a case again in the upper court. She argues that financing comes under general contracts. Judge Uncle said, general contracts means contracts relating to making of the railway track, but not the financing. Again, who won the case? Ritchie. Who lost the case? Ashbury. Yes or no, sir? Sorry, sir. Again, who won the case? Ashbury won the case. Who lost the case? Ritchie. Because ultra-virus activity cannot be ratified even by whole body of the shareholders. Who won the case? Ashbury. Effects of the ultra-virus. Ultra-virus transactions are void ab initio. They cannot be ratified. Directors are personally liable by lifting the corporate will. Shareholders can sue the directors for breach of the fiduciary duty. Shareholders can obtain the injunction from the court of law. If directors doing any ultra-virus transactions, company has the right to secure ultra-virus acquired property because the money belongs to shareholders of the company. Then we discussed about the next class will be liability clause. Which clause? Liability clause. It defines the nature of liability of the members of the company. If it is a company limited by shares, the liability of each shareholder will be maximum to the extent of the unpaid amount on the face value, including premium, if any. And if the number of members reduced below statutory minimum after expiry of the 6 months, the members liability will become unlimited by lifting the corporate will. In case of unlimited company, this clause is not compulsory. This clause will be optional because there is no limit on the liability of the member in case of unlimited company during the winding up of the company. Next clause is the capital clause. Which clause? It defines the maximum amount which a company can raise from the general public. It is also said to be registered capital, authorized capital, or the nominal capital. And the share capital will be divided into number of units known as the shares. The shares includes both equity shares and also the preference shares. Last one is the association clause. It contains a declaration of association by the subscribers. Each subscriber should take at least one share, and opposite to subscriber signature we have to specify is the name, address, and occupation. After the formation of the company, he cannot repudiate the liability. Then, and this clause is not required. This clause need not be altered. So we will not change the subscribers. Subscribers may leave the company, they may die, but they will remain subscribers. They are like parents. Parents will not change. Then next one, if subscriber is the minor, subscriber is the minor, then his guardian is deemed to be subscriber. Next one is the thing. Company's act is like grandfather, MOI is like father, AO is like a son. Son should listen to father, father should listen to grandfather, son should listen to father and also the grandfather. In the same way, MOI should be within the provisions of the Companies Act. AO should be within the provisions of the MOI and also the Companies Act. MOI is a subordinate of the Companies Act. AO is a subordinate of both Companies Act and also the MOA. So, with this, we have done with the Memorandum of Association of the company. Next concept will be Articles of Association of the company. So, what is AOA? AOA means AOA of the company. AOA means AOA of the company as originally framed, which is altered from time to time. Same like MOA. MOA is like a father, AOA is like a son. Next, MOA contains the rules and regulations for the internal management of the company. It contains the rules and regulations for the internal management of the company. So, AOA is the subordinate to the MOA. Subordinate. MOA is the primary document. AOA is the secondary document of the company. It contains the rights and duties of company, rights and duties of directors, rights and duties of employees, rights and duties of shareholders. Next, it is said to be Magna Carta as per Sanskrit. nothing but an internal document of the company. It must be construed strictly. It must be followed strictly. So every member will be binding towards the contents of the articles of association. It contains the rules and regulations for the internal management of the company. So all these things are explained by various case laws. So MOA is for the outsiders, AOA is for the insiders. AOA contains the rules, regulations for the smooth functioning of the organization. It contains the bylaws of the organization. So every company has to file the MOA with the ROC. Once MOA is filed with ROC, it is deemed to be signed by each and every member is binding towards the contents of the articles of association. Every company has to file the MOA with the ROC. Once it is filed with the ROC, it is deemed to be signed by every member, and every member is binding towards the contents of the articles of association. So MOA contains the objectives of the company. AOA contains the how to achieve those objectives. Next one, then it contains rules and regulations for internal management of the company, like face value of the share, issue value of the share, whether to adopt the preliminary contracts or not, directors qualifications or disqualifications, so how to conduct the board meeting, general meeting, how to give the dividend. So all these things will be there in the AOA. There is no limit on the number of articles in the articles of association. We can keep any number of regulations in the AOA, but in the MOA only 6 clauses. Next, binding effect of the AOA. It contains how company is liable to member, how member is liable to company, how member is liable to another member. 3 things will be there in the AOA. How company is liable to member, how member is liable to company, how member is liable to another member will be there in the articles of association. AOA is a subordinate of both Companies Act and also the Memorandum of Association. Every company must have the articles of association. Company can prepare its own articles of association. Company can adopt from the schedule 1. Schedule 1, table A, B, C, D, E is the MOA. F, company limited by shares. G, guarantee company having share capital. H, guarantee company not having share capital. I, unlimited company having share capital. J, unlimited company not having share capital. We can have our own MOA adopt from the schedule 1. But in case of MOA, negative, positive. But in case of MOA, positive and negative. Having share capital, not having. Having share capital, not having. Positive, negative. Positive, negative. Positive, negative. MOA ulta. All these things are not there for you. Difference between MOA and AOA, very fundamental concept. You may ask. You can keep 1 star. Next one is the next concept is the entrenchment provisions, which is important from exam point of view. What is the meaning of entrenchment? Entrenchment means making more restrictive. Making more restrictive at up to 5 stars. How many stars? Very, very important. So AOA contains the entrenchment means making more restrictive. Already some regulations are there in the AOA. We will alter it more restrictively or more flexibly. More restrictively. When you take a New Year resolution, you will try to make yourself more restrictive. I will not smoke, I will not drink, I will do yoga, I will not eat outside food. You are restricting yourself. Will you write like this in the New Year resolutions? I will smoke from tomorrow, I will drink from tomorrow, I will eat non-veg from tomorrow. No. So making more restrictive and protecting the rights of the minority shareholders. Protecting the rights of the minority shareholders. Company can, that means, for example, AOA is there, it is having the 100 regulations. Out of 100 regulations, regulation number 99 dealing with the rights of minority shareholders. So this regulation cannot be altered by the majority shareholders. We discussed an example in the regular class. Yes or no, sir? Well, bachcho, entrenchment provisions can be included in the AOA at the time of formation of the company if company formed after 2013. If we want to include these provisions in the existing company, so in case of public company, we have to pass the SR. In case of private company, we have to get the unanimous consent of all the shareholders. Subsequently, we have to file the same thing with the ROC. Done. This is all about the entrenchment. Very, very important. Next one is the doctrine of constructive notice. Doctrine of constructive notice. Doctrine means theorem. 3 stars. Doctrine means theorem. Notice means assumed, presumed, deemed, implied, quasi, constructed. Theory of the assumed notice. Notice means giving some information. Giving some. Notice means giving information. Constructive means assumption. Once I am informing something with the once I am informing something with the mummy. Sorry. Once I am informing something with the mummy, it's deemed information to daddy. So I told something to my mother. Pakka she will inform to my father. Yes sir, no sir. Once we are keeping something in the notice board, which board? Notice board. It is deemed information to everyone. Yes sir, no sir. Then theory of the assumed notice and implied notice. We have discussed so many examples also for that in the regular class. So once company BOD informing any information with the ROC, it is a deemed information to all the shareholders, society at large. Once BOD files any document with the ROC, it is a deemed notice to all the shareholders and society at large, because ROC is a public office. Once document filed with ROC, it becomes public document. If any person intends to enter into contract with company, don't go to company, approach ROC, read the MOA, other documents filed with ROC, understand them in right perspective, then come to company, enter into contract. If any person enters into contract without consulting ROC, such a person entering into contract at his own risk, company will not be liable. So, what is doctrine of assumed notice? Once company files any information with the ROC, deemed notice to society itself, because ROC is a public office, document will become public document. Doctrine of constructive notice. Here we have a famous case, beta. Kotla Venkata Swami versus Chinta Rama Murthy. So what was happened? If company entering into any agreement on behalf of the company, it must be signed by MD, CS, working director. Three people have to sign on behalf of the company. MD, CS, working director. Here company was borrowing the loan by mortgaging the property. The agreement was signed by CS and the working director, but not by MD. Subsequently, company is unable to repay the same. Whether company is liable? No. Then, because before giving the loan, where you are supposed to go? RBOC. Whether you are approaching RBOC? No. So you cannot get the production of doctrine of indoor management. Next concept is the doctrine of indoor management. Doctrine of indoor management. Tarkan rule. Which rule beta? 15 to 20 stars. Star, superstar, star, mega star, 20 stars. Very, very, very important. What is the meaning of doctrine of indoor management? See, doctrine of constructive notice is beneficial to BOD, detrimental to outsiders. An exception is developed in the form of doctrine of indoor management. About the Tarkan rule, why we'll discuss. Because this was decided by the Royal British Bank versus Tarkan. That's why it is called as the Tarkan rule. Doctrine means theorem, indoor means inside the door, management means taking decisions and implementing the decisions. What is the meaning of doctrine of indoor management? Doctrine of indoor management. For example, so Satish went inside his study room. Which room? This is his study room. Satish went inside and closing the door. Hai. So mummy daddy sitting outside. Satish is inside the study room. But mummy daddy will think he's studying inside. But what if he's doing? He's sleeping. Innocent outsiders will assume that inside something is happening as it is supposed to happen. For example, so with this is our classroom. This is our classroom. So you people are sitting here. I am sitting here, being a faculty. Faculty, students. Yes, sir, no, sir. Why I came inside? To teach. Because I am supposed to teach. Management is outside. Management is yes, sir, no, sir. But instead of teaching, I'm singing the song in the class. But what they think outsiders? They think that I'm teaching only. Yes, sir, no, sir. because I entered into the class to teach. Innocent outsiders think that I am teaching. Sir, no, sir. But actually, I am not teaching. I am singing the song. It increased obligation on faculty. By the time I leave the class, as per schedule, syllabus must be completed. Then it's beneficial to outsiders because they assume that everything is happening what is supposed to happen. Then, so we discussed the study room example, classroom. In the same way, this is not a classroom, this is not a study room, this is the company. We are sending the board of directors inside the company. BOD close their doors because once the affairs of the company are given to BOD, shareholders should not interfere into the day-to-day activities of the company. So, this is company. What is this? Company. Door is closed. BOD is inside. And shareholders are outside. And the other outsiders also outside. Once the affairs of the company are given to board of directors, shareholders should not interfere into the day-to-day activities of the company. Yes sir, no sir. Why I am sending the directors inside? Because to manage the company, to take the decisions, to implement the decisions, they have to manage the company as per companies, as per NOA, as per AOA, as per the resolutions passed in the general meeting and board meeting. Being the outsider, I assume that they are managing the company like that only. It is increase the obligation on the outsiders. Then increase the obligation on the board of directors because the affairs of the company has to comply with the provisions of the company sector, MOA, AOA, and the resolutions. Doctrine of indoor management. So there was a clear na innocent outsiders can assume that inside the company, BOD managing the company as per Companies Act, MOA, AOA, and resolutions passed. Talking of indoor management. There was a famous case, but we have discussed enough good example also, such a beautiful example. Yes sir, no sir. Next, there was a famous case, Royal British Bank versus Tarkan. So what was happened in this case? This was the 1856 case landmark case in the company sector. This case was decided by the Sir John Jervis, Chief Justice. Yes sir, no sir. So what was happened? There was a company called Cameron Coal Brook Steam Coal Swan Railway Company. So what is happening in this case law? So there was a railway company. Which company? Railway company. And this company has taken the loan from the Royal British Bank. Royal British Bank. The loan agreement was signed by the company council, two directors and the CS. As per the articles of association of the company, if directors are borrowing the money, BOD has to take the consent of the shareholders. Shareholders has to specify the amount of loan also, 2 lakhs, 3 lakhs, 4 lakhs. In this case, BOD has not BOD taken the consent of the shareholders. Shareholders did not specify the amount of the loan. So, company taking the loan from the Royal British Bank. Subsequently, company become insolvent. Since company become insolvent, for this company, Tarkand is the official receiver. And bank is asking the money from the Tarkand. But Tarkand said, I will not repay single rupee also. Then bank is asking why. Then Tarkand said, because that is ultra-virus transaction. Shareholders did not specify the amount of loan in the resolution. Then bank filed a case from the Tarkand. Then it was held that bank is assuming that everything was done by the BOD as it is supposed to be done by the AOA. So Tarkand is liable to make the payment to the Royal British Bank proportionately. Clear? समझ में आया? Clear? Royal British Bank versus Tarkand. This case law. Everyone. See, the main purpose of the doctrine is to give the protection to innocent outsider. Which outsider? If you are not an innocent outsider, you cannot get the protection of doctrine of indoor management. So, for example, if the person dealing with the company had the knowledge of the irregularity, there was a famous case law, Harvard versus Patent Avery Company Limited. In this case law, as per the articles of association of the company can borrow up to 1,000 pounds. Beyond 1,000 pounds, they should take the consent of the shareholders. Here, one of the director is giving the loan to company. Who's giving the loan, beta? Howard is the director of the company. Is giving the loan to company. How much? 3,500. How much? 3,500. Without taking the consent of the shareholders. Subsequently, he argues that I'm giving the loan not as a director, I'm giving the loan as a lender, as an outsider. So he wants to get the production of doctrine of indoor management. Judge uncle said, Babu, you don't have two brains. Do you have two brains? One brain as a director, one brain as a creditor? No. So you have the knowledge of the irregularity. You cannot get the production of doctrine of indoor management because you are not a innocent. You know the irregularity. Second case, now, doctrine of indoor management will not be applicable to a person who know knowledge of the articles. There was a famous case, na, Rama Corporation versus TIN General Insurance Company Limited. So there is a company called the General Insurance Company. General, then so there is a company called the General Insurance Company Limited. For this company, TIN is the one of the director of the company. TIN is one of the director. So as per the articles of association of the company, the directors should not borrow. Should not borrow. Director can borrow if he is authorized by the board of directors. Other directors are authorized, then only he can borrow. This will be there in the articles of association of the company. This AOA is filed with the ROC. Can borrow on behalf of the company? Yes. If other directors are authorizing, if board meeting is there, board resolution is there, then only TIN can borrow on behalf of the company. Then, yes, sir, no, sir. Without getting the approval from the other board of directors, TIN is taking the money from the Rama Corporation on behalf of the company. Subsequently, company is unable to repay the loan to Rama Corporation. Rama Corporation filed a case. He said, since I am an innocent outsider, I assume that so internal affairs are complied with. Then court is asking Rama Corporation, before giving the loan, have you approached the ROC? No, sir. Are you reading MOA? No, sir. Then since you are not have the knowledge of the MOA and AOA, you cannot get the production of doctrine of indoor management. Last one is the doctrine of indoor management will not be applicable for the cases involving the forgery. Forgery is void ab initio. There is no consent at all. You cannot get the production of doctrine of indoor management. In this company, there was a CS. CS was issuing the share certificate by making the forgery of the two directors. So that is a void ab initio transaction. You cannot get the production of doctrine of indoor management for the forgery cases. And doctrine of indoor management will not be available if a person behaves negligently. There was a famous case, Anand Biharlal versus Dinsha Company Limited. In this company, an employee was selling the immovable property of the company. So at any cost, employee cannot be authorized to sell the immovable property of the company. Accountant will sell the immovable property. And buyer argues that I assume that everything is happening as per the internal affairs. I assume that the accountant is authorized. Then court held that. So at any cost, a junior accountant will never be authorized to sell the immovable property. You are acting negligently. You are not cautious. We will not give you production of doctrine of indoor management. And doctrine of indoor management will not be applicable where there is no relationship of the principal and agent, where there is no in case of the ultra transactions, doctrine of indoor management will not be applicable. We discussed actively override the MOA and the AOA. Every member has a right to receive the copy of the MOA and the AOA. If member is demanding for the copy of the MOA and AOA and if it is not provided, company and every officer of the company will be punishable with fine of 1,000 rupees per day or 1 lakh, whichever is less. Next, on behalf of the company, if company is entering into any agreement on behalf of the company, it must be signed by the KNP and officer authorized by the board of directors. And if company is issuing any check or bills of exchange or any other negotiable instrument, it must be signed by the any person authorized by the BOD by affixing the common seal. With this, we have done with the revision of the MOA and AOA. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. Yeah. Welcome back, sir. We'll revise the rapid revision of the share capital chapter from CA Foundation. First of all, What is the meaning of the share? What is the meaning of the share? Share means share in the share capital. It includes stock. Stock means conversion of fully paid up shares into one single fund. For example, Satish is having 10 shares. Satish is having 10 shares. Each share is 10 rupees. Paid up also 10 rupees. Satish said to company, "Sir, you take these 10 certificates, give me one certificate. That certificate is said to be stock. Share means share in the share capital. The share capital of the company divided number of parts. Each part is said to be share. So stock means conversion of fully paid up shares into one single fund. Share capital of the company will be divided into number of indivisible units. Each indivisible unit is said to be share. And shares are of two types: preference shares and equity shares. As we discussed in the regular class, preference shares are like a daughter, equity is like a son. Preference means priority. Preference means we discussed. During the life of the when sweet is in our home, so first we have to go the jalebi to sweetie only. When she is leaving the home after marriage, so she will take the share in the property. Then, so when she is in our home, being a sister, we have to give the priority to sweetie. When she is leaving, also we have to give the priority to sweetie. In the same way, during the life of the company, they have the right to receive the dividend priority over the equity out of net profits. During the winding up of the company, they have the right to take the repayment of the capital priority over the equity out of the net assets. Out of the so right to receive the dividend to during the life of the company, right to get the repayment of the capital during the winding up of the company. If these two priorities are there, usko bolte hain preference share. It's like a jalebi, it's like a building. And equity share, there is no much definition, but all the shares other than equity is said to be all the shares other than preference is said to be equity. Here the ordinary shares, shares other than the preference is said to be equity shares. Equity shares are two types: EVR and DVR. EVR means one share, one vote, 10 shares, 10 votes. DVR means there is no voting rights in general. One share is equal to 0 votes. 10 votes also, but generally one share is equal to 0 votes only. Very important topic. We'll discuss again in the CA Inter. Done. Next one, classification of the share capital. Classification of the first one is the authorized capital. Which capital, beta? It defines the maximum amount which a company can issue for the lifetime. How many shares a company can issue for the lifetime is said to be authorized capital. Which capital, beta? For example, company is authorized to issue 1 lakh shares, 10 rupees each. This 10 lakhs is the authorized capital. Out of this 1 lakh shares, if company is bringing the 7 lakh shares to 8 lakh shares to market, इसको बोलते हैं issued capital. So company is keeping 20,000 shares with itself. इसको बोलते हैं unissued capital. So how much shares are there? 1 lakh. How much bringing into market? 80. How much not bringing into market? 20. This 80 is the issued capital. It is that part of the authorized capital which is issued to public for purchase or subscription. It is that part of the authorized capital which is not issued to public for subscription. They will sell in the future. Out of these 80,000 shares, we can able to sell 75,000 shares, unable to sell 5,000 shares. So it is that part of the issued capital which is subscribed, purchased by the public. Unsubscribed, it is that part of the issued capital which is not purchased by the investors. So we are selling the 75,000 shares, each share 10 rupees. Out of this 10 rupees, let us call 6 rupees per share. इसको बोलते हैं called up capital. It is that part of the subscribed capital which is demanded by company, And 4 rupees we are not asking now, we will ask in the future. It is that part of the subscribed capital which is not demanded by company. Out of this 6 rupees, shareholder is out of the 75,000 shares, for 70,000 shares, shareholders are paying 6 rupees. For 5,000 shares, they are paying only, they are not paying the 6 rupees. So it is that part of the called up capital which is paid by subscriber. How many shares were sold by 75,000? How much we are asking? 6 rupees. How many people paid 7 out of the 75? 70,000 shareholders paid 6 rupees paid up capital. But this 5,000 is there, they are not paying the full amount. उसको बोलते हैं Carlson areas. Carlson done. So this question came so many times in the exam in CA Foundation. Classification of the share capital. Next, shares shares are as per section 44 of the Companies Act. Shares are movable property. We can buy, we can sell the shares in the share market. And shares shall be as per section 45. As per section 45 of the Companies Act. So if company have the physical shares, A shares, physical shares, they should have the distant to number, separate number, share 1, share 2, share 3, share 4. But there is no numbering for the electronic form of the shares. It is not applicable to the e-shares. Electronic shares are demat shares. Demat means dematerialized form of the shares are electronic shares. That's it. So with this, we have done with the revision of the share capital. So remaining part we'll discuss in the next class. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care.